What happens when a tech CEO worth $180 million decides that 11 people who work 60-hour weeks building his products simply don't need to be paid? This man walked into my courtroom with 2 expensive attorneys and the specific confidence of someone who has spent 20 years in rooms where confidence alone is usually enough. He had not paid 11 interns a combined $94,000 in wages that their contracts, their time records, and the law all said he owed them. One of them built a product that generated $2.3 million for his company in the 7 months he spent reviewing whether to pay her. And he stood in my courtroom looking at me like this proceeding was an administrative inconvenience he hadn't budgeted time for. When I asked him directly, on the record, in front of those 11 people, whether he knew they hadn't been paid, what he chose to do instead of answering is the reason this story exists. But what nobody in that courtroom anticipated, what even his attorneys hadn't prepared for, was the single document that David Park placed on the record last. A photograph. A $400,000 boat in a marina. A caption that read, "Built different. The difference between people who make things happen and people who wait for things to happen is exactly this wide. Go build something." Posted 6 weeks after the first unanswered phone call. The room went completely still, and the man who had spent 20 years telling the world he built things was about to learn what it actually means to build something, and what it costs when you make other people build it for you, and then decide the word guaranteed doesn't apply to them. Wage hearings are routine by nature. They arrive on the docket with a case number, a plaintiff count, and a dollar figure, and they are generally resolved in the time it takes to establish that the dollar figure is owed and order it paid. When the file landed on my desk on a Tuesday morning in April, I read it once, set it down, picked it up, and read it again. Then I set it down a second time. Then I picked it up and read it a third time. The plaintiffs were 11 people, the youngest was 22, the oldest was 26. Recent graduates, computer science, software engineering, data analytics, who had accepted internship positions at a technology company called Vertex Systems on the basis of offer letters that described their stipends in plain language, the word that appeared directly before each dollar figure was guaranteed. They had worked 4 to 6 months each, full-time, some of them logging 60 hours a week, all of it documented in their own time records. At the conclusion of their internships, each of them had received a notification from the company's HR portal informing them that their stipend payments had been reclassified as performance contingent compensation pending a review. That review had been ongoing for 7 months. The portal's status message had not changed in 7 months. Your compensation review is in progress. Thank you for your patience. The lead plaintiff was a 24-year-old named Selin Iden, first-generation college graduate. Her parents had run a dry cleaning business out of the same strip mall for 19 years. She had attended a state university on scholarships, financial aid, and part-time work, graduated with a 3.9 GPA, and accepted the Vertex Systems internship over 2 other offers because the stipend was the only version of the math that worked. She worked 58 hours a week for 5 months. She built a customer analytics module that the company deployed to production. It had been generating revenue ever since. David Park filed for all 11 of them simultaneously, and that filing is the reason Marcus Vane was in this room that morning. What the file described was not a processing delay. It was a system, and the difference between a delay and a system is the difference between an error and a decision. Every call Selin made to the finance department was routed to an automated menu. Every option on that menu directed her to submit her inquiry through the HR portal. Every submission through the HR portal triggered an automated response acknowledging receipt and directing her back to monitor her compensation review status, which the portal displayed without variation as in progress. The loop was complete. There was no point of entry that produced a human being, a timeline, or an answer. There was only the message and the instruction to be patient, and the implicit suggestion that patience was what the situation required. It had worked before. David Park documented 6 interns across 4 previous cohorts who had received the same portal notification, made the same calls, received the same automated responses, and eventually stopped. They stopped because they were 23 years old and carrying student loans and didn't know they could file or couldn't afford an attorney, or had accepted, as the system was designed to make them accept, that waiting was the appropriate response to being owed money by a company worth $340 million. During those same years, Vertex Systems completed 3 venture capital funding rounds and raised $340 million. Marcus Vane's name appeared on innovation lists in 4 separate industry publications. He purchased a $4.7 million apartment. He drove a $280,000 car. And 6 weeks after Seleniden made her first unanswered phone call to the finance department, he purchased a 42-foot boat. David Park had been documenting the contrast, one exhibit at a time, for 8 months. By the time the labor board forwarded the complaint to this court, I had already read enough to know what kind of mourning this hearing was going to require. Marcus Vane arrived at the courthouse in a silver Tesla, the specific model that costs more than most people's first homes. Both facts visible to anyone standing on the courthouse steps that morning, which several people were. He was accompanied by 2 attorneys from a firm whose hourly rate I am familiar with from previous appearances in this building, a personal assistant who carried a document case, and the specific bearing of someone who has assessed a proceeding as manageable before entering the room and has not yet encountered a reason to revise that assessment. He moved through the courtroom without looking at the 11 people seated at the respondent's table. He looked at the room instead, the gallery, the press section, the cameras that had required permission to be there, and something in his expression suggested he found it smaller than he had expected. He took his seat at the petitioner's table, opened a document folio his assistant placed in front of him, and arranged himself with the unhurried ease of a man who has decided that projecting composure is the same thing as possessing it. Seleniden was already at the respondent's table when he entered. Dark blazer, a folder placed in front of her with her hands folded on top of it. She did not watch him come in. She had been watching this proceeding approach for 8 months and had, somewhere in that time, made the decision that the entry of any particular person into a room was no longer the thing she gave her attention to. David Park sat beside her with a laptop, a printed exhibit binder, and the particular stillness of someone who has been building toward a single morning for 8 months and has no intention of wasting a minute of it. I entered at 9. I called the hearing to order. Vane's lead attorney rose and began to present the company's position. The attorney's presentation was organized and precisely delivered. The internship agreement contained a compensation review provision, he argued, that explicitly preserved the company's authority to assess stipend eligibility based on performance outcomes. The interns had been compensated with mentorship, with industry exposure, with the professional development that an internship at a company of Vertex Systems standing represents. The analytics module, while deployed, had been developed under supervisory guidance and did not constitute independent compensable work product. The review process was ongoing. The company's position was that no payment was currently due. I listened to every word. Then I asked my first question. Counsel, the offer letters signed by each of the 11 plaintiffs describe the stipend as guaranteed compensation. Can you identify for this court which specific provision of the internship agreement authorizes the company to reclassify guaranteed compensation as performance contingent after the work has been performed and the internship has concluded? He cited a clause by section number. I asked him to read it aloud. He found it and read it. The clause described a performance review process applicable to employees during active employment. The internships had concluded. The 11 plaintiffs were no longer employed by Vertex Systems. The clause, read exactly as written, did not apply to concluded internships. The attorney recalibrated without acknowledging that he had needed to. Then David Park opened the exhibit binder. 11 sets of time records, each intern's documented hours, week by week, for the full duration of their placement. 11 offer letters with the stipend amounts and the word guaranteed printed in plain text. the HR communications, the unanswered calls, the automated email responses, 7 months of the portal message. Then the analytics module, its deployment date, its current status in Vertex Systems' production environment, its documented revenue contribution, $2.3 million in the 7 months since it went live. Marcus Vane's expression was the expression of a man watching a room that has not yet recalibrated to accommodate what he is accustomed to. Then David placed one final document on the record, and the room went very still. He placed it without announcement and without commentary. He simply added it to the exhibit log, turned the printed page toward the room, and sat back. It was a screenshot from Marcus Vane's personal Instagram account. The photograph showed him at the wheel of a 42-foot vessel in a marina, a boat that carried a purchase price of approximately $400,000. The photograph was dated 6 weeks after Selenai Din had made her first unanswered phone call to the Vertex Systems Finance Department. The caption read, "Built different." The difference between people who make things happen and people who wait for things to happen is exactly this wide. Go build something. The courtroom read it in silence. Not the silence of a room waiting for something to happen, but the silence of a room that has just had an 8-month case compressed into a single image and understood, without needing it explained, exactly what the compression revealed. The portal message and the boat in the same frame, the first unanswered call, and the caption in the same timeline. The word guaranteed in Selen's offer letter and the word built in the caption, sitting in the same proceeding, pointing in opposite directions. Marcus Vane read it from across the room. His expression underwent a specific recalculation, not remorse, not recognition, but the particular adjustment of a man understanding for the first time that the room does not see what he intended the post to communicate, and that there is no reframing available that will change what the date on the photograph means in the context of everything that preceded it in the exhibit binder. David Park closed the exhibit binder. Nothing more was needed. Then I looked at Marcus Vane directly, and I asked him the question. I asked it at the same volume I use for everything in this courtroom. No shift in register. No pause to indicate that what was coming was different in kind from anything else the morning had produced. Mr. Vane, the 11 people sitting at that table built something. They built it for your company. They built it for 60 hours a week in some cases. One of them built a module that has generated $2.3 million in revenue in the time your company has spent reviewing whether to pay her. I want to ask you something plainly, and I want you to answer it in this room, on this record. Did you know at any point in the 7 months that review has been ongoing that these 11 people had not been paid? Vane's lead attorney rose from his chair. I raised one hand without looking at him. I asked Mr. Vane. The attorney sat. The room held completely still. What followed before Vane spoke was not the silence of a man composing his answer. It was the silence of a man discovering that the operational language, which has reliably closed conversations for 20 years, is not closing this one. He said the compensation review process was handled by his HR team. He said he was not personally involved in the administration of internship stipend determinations. He said he trusted his team to apply the company's compensation framework appropriately. He said the question implied a level of personal engagement in operational decisions that didn't reflect how a company of Vertex Systems scale actually functioned. I told him what the question actually was. Mr. Vane, I am not asking about your HR team's operational framework. You posted a photograph of a $400,000 boat 6 weeks after Selenai then made her first unanswered phone call to your finance department. One of the people at that table built a module that has generated $2.3 million in revenue while your company reviewed whether to pay her for building it. Their offer letters use the word guaranteed. I am asking you whether you knew that 11 people who worked for your company had not been paid. And I want you to understand that your answer, whatever it is, will be entered into the permanent record of this proceeding. The room was completely still. Vane looked at his attorney. His attorney gave a barely perceptible shake of his head. Vane looked back at me. What moved through his expression was not remorse and not recognition. It was the specific recalculation of a man who has just understood that this room requires a different kind of management than the rooms he is used to, and who does not currently have the right tools for it. He said nothing that constituted an answer. In a courtroom, that kind of silence enters the record as fully as any spoken word. I noted it. Then I issued my ruling. 5 orders. Full stipend payment plus interest to all 11 plaintiffs within 10 business days. Non-compliance to constitute contempt. Additional damages of 200% of the unpaid amount under the state wage theft statute, bringing the total judgment to approximately $282,000. A formal referral to the State Labor Board for a complete audit of Vertex Systems' internship compensation practices across the preceding 5 years. A referral to the State Attorney General's Office for review of potential criminal wage theft charges. And Marcus Vane personally ordered to appear before this court in 90 days with documented proof that all payments had been made and all affected interns individually notified in writing. His non-answer to a direct question regarding his personal knowledge of the non-payment was entered into the transcript of this proceeding and will remain there permanently. Vane stood. His attorney moved beside him and said something about appeals and procedural auctions. Vane looked at the room, not at me, not at Celine, not at the 10 other people at the respondent's table, with the expression of someone processing not accountability but logistics. I said, "Mr. Vane, the record of this proceeding is public. The $2.3 million your company generated from work you didn't pay for is also public. Every investor, every partner, every publication that has put your name on a list of innovators will have access to the same record you do. I suggest you make the payments." He walked out. The room watched him go. Celine Iden did not watch him go. She had opened her folder and was looking at the offer letter, the single page she had signed 14 months earlier, the stipend amount printed at the bottom of the first page, the word guaranteed appearing directly before the dollar figure. She had been looking at that word for 8 months. She did not need to look at Marcus Vane's exit. Vertex Systems made the payments within 7 business days, 3 days ahead of the court's deadline. On a Thursday morning, the amount deposited into Celine's account was $14,300 in stipend and $2,847 in interest. She looked at the notification for a long moment. Then she called her mother. The State Labor Board audit opened within 30 days of the referral, surfaced 17 additional cases across 5 internship cohorts over 4 years, stipend payments delayed or reclassified under nearly identical circumstances. 6 of those cases involved interns who had never filed. The audit findings were forwarded to the AG's office. 3 technology industry publications ran follow-up coverage. 2 removed Vane from their ongoing recognition programs. 1 published a full investigation into internship compensation practices across the venture-backed technology sector, naming Vertex Systems as its central case study. The piece was read 4.1 million times. 14 months after the hearing, the state AG filed criminal wage theft charges against Vertex Systems as an entity, and Marcus Vane's communications team released a statement. Like all statements of its kind, what it chose not to mention told you everything. It said that Vertex Systems takes its obligations to all workers seriously and is cooperating fully with all relevant regulatory processes. It did not mention Celine Iden. It did not mention the analytics module or the $2.3 million or 7 months of a portal displaying the same message while that revenue accumulated. It did not mention the boat or the caption or the date on the photograph or the question that Marcus Vane had declined to answer on a Tuesday morning in April. The criminal charges carried a maximum penalty of $1.2 million in fines and 5 years of mandated compliance monitoring. David Park testified before the state legislature's Labor Committee on wage theft patterns in the internship economy. The exhibit binder he had built across 8 months became part of the legislative record. The bill that followed, the Earned Wages Protection Act, requiring all companies operating internship programs to post stipend payment bonds before any intern begins work, passed and was signed into law. Sheila Knighton received 3 job offers within 2 weeks of the hearing. She accepted the one with the best stock options from a manager who said in her first interview that his company paid people what they owed them and was sorry that still needed to be said. She keeps the offer letter in a folder in her desk drawer, not as a wound, as a definition of a word she intends to keep holding people to. I keep a copy of the Instagram post in the top drawer of my desk. The boat, the caption, the date, not as a trophy, as a reminder that contempt for the people who build things is rarely hidden. It is usually posted publicly with a location tag and 14 words 6 weeks after the first unanswered call.